Chapter 3, the legal, regulatory, and professional environment in which fraud examiners operate. Now, neither Mary Jo Kranecker nor Dick Riley are attorneys. I am. So I have corrected them on a couple of these things, but they're not too far off. But any changes I will point out to you folks. Okay, the introduction, we talk about the Daubert Challenge, and that has to do with testifying in court as an expert witness. And it comes from the 93 Supreme Court case, Daubert versus Merrill Dow Pharmaceuticals, which the court articulated a new set of criteria for the admissibility of expert testimony. So we'll be talking about that in a bit. Up until 93, different courts, I mean, you can't just bring in somebody who says, oh yeah, I'm an expert on this, and I believe that, you know, whatever, it was a space alien that caused the collapse of the sinking of the ship or what have you. No. So 93 Supreme Court said, okay, we've got to come up with a good standard as to who can be called and what they can testify to as an expert witness. And this, of course, affects fraud examiners. And we talked about last time, the fraud triangle, while we fraud examiners love it, courts have said, yeah, it's really not admissible evidence. So here is what, so here we have those cases I think we talked about last time, Huff versus Heaps, in which the appellate court there failed to locate even a single case in which the fraud triangles, should be singular, theory has been adopted as reliable scientific method. It really hasn't, because it isn't. Travis versus State Farm, they excluded the fraud triangle testimony, the judge noting that the triangle relies more on professional judgment than hard science, and that's true. Kremski versus Kremski, the court noted that the expert witness can't speak to the subjective belief of a party because it would basically amount to unsupported speculation. Okay, so a fraud triangle is a useful investigative tool, but it's it really shouldn't be used in court to, possibly convict someone of fraud. Okay, so here's what's in the chapter. Module 1, overview of criminal and civil justice systems, within which forensic accountants and fraud examiners work. Module 2, we're going to talk about legal rights coming out of the U.S. Constitution. And you may be hearing a lot about them in the news lately, especially due to the folks over there in ICE and Border Patrol and Customs and Border Enforcement who have been possibly violating the various rights that people have. But it's been in the news a lot. Module 3 takes a look at the U.S. Constitution's Fourth Amendment right, in particular with regards to probable cause. Module 4, review the rules of evidence by considering the primary attributes of evidence, because that determines whether it's presented in court. There's more. 5 and 6, we have overviews of the criminal and civil justice systems. Module 7, take an initial dive into basic accounting. And again, I'm going to be skipping through this chapter because you folks, have all taken accounting courses, so I don't think you really need this. So you should know this already. Hopefully you know it already. And but this is the type of case, this text rather, I'm told is also used in criminal justice majors and also even things like journalism. So they need that basics in accounting. I think I mentioned before, when I worked in the federal court, almost a week did not go by that I did not get called into one of the other federal judges' chambers to, explain to them something about accounting because they knew I was a CPA. I'd worked as a CPA. I'd, worked at Deloitte as an auditor, and they They didn't. And it's like you can actually make it to the federal bench and not know enough about accounting. So we'll talk about that. Module 8, overview of key elements of the regulatory system. And that's relevant here. And Module 9, an introduction to key organizational stakeholders who oversee the development of accounting information, including who's responsible for internal control. Okay, here's Module 1. As we know, fraud can be prosecuted criminally. So the state's attorney or U.S. attorney will prosecute you, possibly put you in jail. Or civilly, you defraud someone and you get sued for doing that. And very often, fraud cases, prosecutors, unless it's a big dollar amount fraud, prosecutors won't bring a fraud charge, as I say, unless it's a big dollar amount or unless you defrauded the government, because they would tell folks, hey, just hire a lawyer and sue them and get your money back. But big fraud cases, they will prosecute. So why do people obey the law? Well, again, we talk about the deterrent effect of things and the fear of getting caught and punished. Most people are law-abiding. And one of the most important aspects of the American and Western judicial system is the willingness to accept the outcomes of the legal process. And I saw that when I worked in federal court as a law clerk to a federal judge. I also have acted as an arbitrator for the Circuit Court of Cook County, where small claims cases, the court will send them off to what's called mandatory arbitration. So rather than taking up the time and space of going to trial, plus it can take years before you get a civil trial in Cook County. It's been improved vastly because of this. They put in the mandatory arbitration system where you plead your case in a limited amount of time. Again, these are small claims cases, in front of a panel of 3 attorneys who then will, come up with a, either fine for the defendant or fine for the plaintiff and say, okay, you should, defendant, pay the plaintiff X amount of dollars. And I have seen cases where at the end of it, we ruled against someone. Okay, they brought this case, they tried it, in some cases without an attorney, and they lost. The panel of arbitrators fined for the defendant. But at the end, they say, that's okay. I just wanted my day in court. And we hold it, in a serious sort of courtroom setting. People just want their day in court and they accept the outcome. Now, if you don't, you can appeal, even from the arbitration panels. But most cases, I think it was like 90% of cases that get sent off to arbitration don't get appealed because people just want their day in court. The criminal justice funnel is that idea that, crime, a lot of crime, sometimes, a lot of it people get away with. But when they don't, they get caught. And then they go into the system. And very often they do not get prosecuted and brought to trial and convicted and sent to jail. There are a lot of, ways, a lot of stops along the way. Prosecutors have what's called prosecutorial discretion. They don't have to bring a case. And they'll look at a case and go, we think, you did it. But we'll only bring a case, a lot of prosecutors, we'll only bring a case if we feel that we have better than even odds to win the case. And so I saw a thing recently where a guy with a camera was videotaping another guy and got like right up into the guy's face and may have touched him. And the guy being filmed punched the guy with the camera. Now, is that assault or did the puncher have a reasonable belief that he was going to be assaulted and performed a preemptive strike? A prosecutor might say, well, I think we could prosecute, but it's very likely we'll lose the case, and they don't want to do that. So those cases get dropped. A lot of cases, they have a plea bargain, so you don't have a trial. You might, if it's not a big crime, give the person probation. Say, okay, we're going to give you probation for a year. You be a good boy or girl for the year, and come back to court in a year. And if you haven't violated any laws in that year, then we will just sort of make this go away. A lot of cases are brought and then dropped. But very few go get through the tunnel and then drip out at the bottom as a trial, followed by a conviction, followed by incarceration. Additionally, we have all those regulatory agencies that have regulations, that promulgate regulations because they've been empowered by either Congress or a state legislature to promulgate regulations, and they have the strength of law. Okay. So very often the regulatory agencies that fraud examiners and forensic accountants deal with are the U.S. Securities and Exchange Commission, created under the 1934 Securities Exchange Act. And then as part of that is the more recently created PCAOB, happily called Peekaboo, the Public Company Accounting Oversight Board. Then we have all sorts of governmental agencies that regulate activities involving utilities, communication, air transportation, environment. I knew a guy who was a fraud examiner for the Environmental Protection Agency, looking into companies that pollute, but then phony up their records with regards to how they pollute. For example, he had one case he was telling me about where this industry, they were allowed to dispose of a certain amount of wastewater into a flowing river. But on the pipe leading to the river, they had a valve, or rather a meter that would record how much wastewater was going out. And according to their reports, they were always in compliance, yet they were getting complaints of excessive pollution in this river. And so the fraud examiner with the EPA went and conducted surveillance and found that what they would do is this pipe, or this meter was attached to this pipe, and they would go out at night, disconnect the meter, flip it around, and then run some more wastewater through it. And it would be like reversing the odometer on your car. So which would get up to or go past how much they could pump into the river. They flip the meter around, and then the meter would deduct the number of gallons going into the river. So yes, even the EPA has fraud examiners. And then, of course, our good friends at the Internal Revenue Service, and I always call them good friends because, they might be listening. They also involve, you could be a fraud examiner either working with them or working for a client who is opposing them. All right, let's talk about the rights of the individual. So going through our Constitution, as we know, it was passed, and then it was like, we really should incorporate into the federal Constitution certain rights that the people should have vis-a-vis the government. Okay, these are all about what rights you have with regards to the government. Now, originally, they only applied to the federal government, not to the state governments. But as we see at the bottom of this list, the 14th Amendment, following the Civil War, said, all those rights you have, with regards to the federal government, also with regards to your state government. And of course, the First Amendment deals with freedom of speech, freedom of religion, freedom to assemble, etc. We don't get involved in that too much here. Second Amendment, the right to bear arms. The third, we'll talk about the fourth in a moment, but the Fourth Amendment right now is we're going to have a whole much more on this. The prohibition against unreasonable searches and seizures. Now, what's unreasonable? Well, people disagree as to what's reasonable and unreasonable. And so we rely on the courts, especially the Supreme Court, to tell us what is a reasonable or unreasonable search. And again, this is with regards to the government, whether it be the federal government, a state government, or because the states are the ones who charter, counties and cities and villages and townships and all the rest. It's a government actor, okay? Must be involved in a Fourth Amendment dispute. Fifth Amendment provides that a person cannot be compelled to provide incriminating information against himself in a criminal case. So it's, I plead the fifth. I'm not going to, testify against myself. It's even been extended to the fact that if you're on trial and you say that, no, I'm not going to take the witness stand, the prosecutor cannot tell the jury, and he wouldn't even take the witness stand and, tell us his side of the story. He doesn't have to. He has a right not to say anything. And so cases where a prosecutor would say that, you get an immediate mistrial. Throw it out, start from scratch. That is considered very bad because you have a right not to testify. So don't make it sound like something's wrong. Sixth Amendment provides that an individual has a right to an attorney to defend himself and the right to confront witnesses against him. So again, you have a right to an attorney. And then at trial, you have somebody wants to testify against you, great. You are entitled to, you or your attorney is entitled to cross-examine that witness. The 14th Amendment, again, after the Civil War, said, all of these rights in the federal Constitution that applies to the relationship between individuals and the federal government, we're going to extend that to the state governments as well. So the federal law enforcement official cannot perform an unreasonable search and seizure. Neither now can a state law enforcement official. And again, it entitles people to due process of law. Okay, so you are entitled to, the process. You get arrested, you get arraigned, you get tried, convicted, then sent off to jail. You're allowed, whatever the process of the law is, you're entitled to it. And then also equal protection of the law. The government cannot carve out, certain things for some people and certain things for other people. We're all considered equal under the law. Now, as employees, individuals have an obligation to cooperate with their employer or be subject to dismissal. So this comes up every now and then. And it's the idea that, again, these rights, apply to your relationship with the government, or as it's sometimes called, a state actor, whether it be the federal government, state government, county, city, whatever. A government actor. A private employer, no. I had a case when I was working as a law clerk of a professor at Northwestern University who happened to be up for tenure that year. And a person that apparently she opposed politically was coming to campus to make a speech, and she was against that. And she organized students to confront this person. And when this person came into the auditorium at Northwestern University, she and the students stormed the stage. She and the students they went to a butcher shop and got bags of pig blood that they then spread all over the auditorium. And this professor went to the microphone and said, if he tries to come out here and talk, he'll be lucky if he gets out of here alive. I'm going to turn my camera on since I'm talking now. Okay. I got to tip my camera up right now. It's looking right at the keyboard. Okay. He'll be lucky to get out alive. Well, that's a threat on someone's life. So the tenure board said, no, I don't think we're going to give her tenure. And it was upheld by the, no, actually, I'll turn that around. The tenure board went ahead and said, yeah, she should get tenure. Her department said, yeah, give her tenure. Her college said, yeah, give her tenure. But then the president of the university said, no, I'm not going to put a faculty member on on the university and give them tenure after they've threatened someone's life and led this demonstration. And as without tenure, she was let go. She sued in federal court for Northwestern University violating her First Amendment right to free speech. Now, not even getting into what she said, the case got filed. It was assigned to my judge, and we got rid of it quickly because we said, whoa. Northwestern University is not a state actor. It's unlike Governor State University. It's a private institution. They don't have to give you a right to free speech. Now, maybe there's a union contract that provides that, or employment contract. You haven't presented that to us. You're filing under, the violation of civil rights and the violation of First Amendment. It doesn't apply here. Case dismissed. And she was fired from Northwestern. She went on to get a job at Rutgers University, which is the state university of New Jersey. So now she has the protection of the First Amendment. Now, whether or not she's done any of those things up there, I don't know. But again, these rights, these constitutional rights, apply to your relationship with the government, not to private employers. Now, Governor State, we are entitled to all the protection of the Constitution because we're a state actor. Okay, there you go. So federal law and many state laws also protect employees who report improper or illegal acts of their employer. Those are called whistleblower laws. So if a employee blows the whistle on a company, saying that they were defrauding shareholders or what have you, while you don't have the right to free speech to do that, you're a whistleblower. The government says, that's a good thing. We want to encourage people to come forward with this information. You try firing them, we're going to make you take them back and give them back pay as well. So those are whistleblower laws. Okay, turning off my camera again. Moving on. Okay, so what about these things such as the rights of individuals in interviews with regards to searches, surveillance, discharging a suspected wrongdoer from employment, and privileges? Let's talk about each. Okay, interviews. Now, if you are a state actor or especially law enforcement, the case Miranda versus Arizona, same time was another case, companion case, Escobedo versus Illinois, but established that when you are arrested and prior to a questioning in custody, so you have to be in custody. You can't just be out on the street and they start asking a question. But if they're in custody and they're asking you questions, they first have to read you your Miranda rights. And as many of you know, they say something along the lines of, you have the right to remain silent. Anything you say may and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney before questioning, one will be assigned to you before questioning. Do you understand these rights? Do you wish to give up the right to remain silent? Do you wish to give up your right to an attorney? Okay, so there you go. You have a right to remain silent, and you have to be told and it's not just answers, can be anything you say can be used against you. Okay, it might not even be an answer to a question. So I disagree with answers. It could be like, after being in custody for a while, go, hey, can you guys get me something to eat? I haven't eaten all day. Last thing I ate was a ham sandwich for lunch. Well, maybe at the crime scene there was a half-eaten ham sandwich or something like that. Okay, but so very often, best policy is if they read you your Miranda rights, know that they think you did it. And as an attorney, I will tell you the best thing you can do is invoke your right to remain silent and then say nothing after that. Well, invoke your right to remain silent and say you want a lawyer, and then say not a word after that. If they may try to get you to talk or change your mind on that. Don't, because as we'll see in later chapter, we talk about interviewing or interrogation. Detectives will go to training for interrogations and such, and they will cajole you to get information out of you. And very often, thank goodness, some bad guys are really dumb, or they think very highly of themselves, and they think they can talk their way out of it. What they're actually doing is just digging a deeper hole for themselves. So I'm just telling you, if you ever hopefully you didn't do it, but don't answer, so invoke your rights, okay? And again, you have a right to an attorney. If you can't afford an attorney, one will be provided at no cost. You have to be told that as well. You have a right to legal counsel, your own, or if you can't afford one, a public defender. Now, private employers do not have to offer due process of law. Okay. Again, the rights in the Constitution only refer to government actors. However, there are also common law protections on what an employer, even a private employer, can do or not do. And then we'll talk about confessions in a little bit. So, employee interviews, as long as a non-public entity is conducting the interview, the employee does not have the right to have a lawyer present. Okay. And if you refuse to answer their questions, they'll simply say, okay, you're fired. All right. With regard to the 14th Amendment, private employers do not have to offer employees due process of the law. But some of the common means by which federal rights are altered are via employment contracts, collective bargaining and other union agreements, various non-discrimination statutes, and the Fair Labor Standards Act. So even if you don't have constitutional protections, folks like myself, I have a union contract, and that has provisions as to how disputes are to be handled with the university, and the university is obliged to follow the contract. Additionally, we have non-discrimination statutes that limit what an employer can do, along with the Fair Labor Standards Act, which also has employee protections. So just because you don't have the constitutional protection doesn't mean you don't have any. Then there are the common law protections with regards to interviews. Okay, this is, again, it's a private non-government employer. Common law says you have to minimize the invasion of the employee's privacy. Okay, so they can't, ask you questions and go into details about your private life. All right. Limitations on interview content to job duties and responsibilities. Limitations on the public disclosure a private fact. So if during the interview they find out that you weren't on the job because you were having an affair with someone, they can't go out and broadcast that, okay? Limitations on intentional infliction of emotional distress. Limitations on defamation. Again, those are unfounded facts and accusations made by the interviewer. Again, this is why we conduct interviews one-on-one. You don't do it in a crowded room where others can hear, because that could lead to a defamation lawsuit. You have a duty to deal fairly and in good faith, and no false imprisonment. In other words, you don't call the person in for an interview, you put them in a conference room, and then you lock the door behind them so they can't leave. That's called imprisonment. If confessions are made, in order to be valid, they must be deemed voluntary. Okay, no forced confessions. You cannot extort someone into confessing. Confessions cannot be obtained as a result of coercion or under threats of violence. Promises by the interviewer of leniency can nullify a confession, because then it's thought, well, were they really being voluntary? And small deceptions are generally permitted and won't risk the validity of the confession. We'll talk more about this when we get to the interviewing chapter. What about searches? Again, Fourth Amendment protects individuals against unreasonable searches and seizures by the government. So public employers like me, okay, not an employer, I'm a public employee. So governor states, okay, nonetheless are not required to obtain a search warrant when they conduct workplace searches for investigations of workplace misconduct. So if they think that I did some sort of misconduct at governor state, they don't need to go out and get a warrant from a judge in order to come in and search my office. Okay, it's, you know, on governor state property. All right, as long as they have, you know, a good reason for that. So when is workplace search reasonable? When it's likely to reveal evidence of work-related misconduct and it's necessary to further investigation. Search limitations, though. If you have exclusive control. So for example, I drive my car to the Governor State parking lot. Hey, my car is on the Governor State property. And they want to search, excuse me, when I open a Pepsi, they want to search the trunk of my car. Whoa, 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 whoa. I have exclusive control over the trunk of my car. Okay. You can't see in it. You don't go in there. Okay. Or if I have, you know, even in the backseat of the car, let's say I have a briefcase that's locked. I have exclusive control over that. You can't just go in. You want to look in there, get a warrant. And Mary Jo and Dick Riley used the wrong term. It's not fruit of the forbidden tree. It's fruit. It's not from. It's fruit of the poisonous tree is the term we use in law. And that is to say that if you find something during an illegal search, you cannot then use that to find something else. Okay, so let's it can't be used against you. So let's say Governor State conducts that illegal search of my car trunk, and they find a gun in there, and they go, aha. And then they take that gun and they examine it, and then they can trace it back to some other crimes. Guess what? They can't use it against me because that gun was found during an illegal search. And that is the fruit of that poisonous tree, the poisonous tree being the illegal search. You cannot use that against me. Now, maybe I did do that other crime with the gun. You know, you're going to have to find some other evidence to prove that I did the crime, that you didn't get illegally, that the illegal, you know, search bars law enforcement, bars prosecutors from using the evidence that's found. Surveillance. Surveillance can be more complex than interviews and searches. I would say in your practice as fraud examiners, if you want to do surveillance, please, please, please talk to counsel first. So if you're working for a company, talk to corporation counsel, and maybe have them call an attorney that deals with this stuff. Types of surveillance: fixed point surveillance. So you set up a place where you're watching. You buy the or you rent the apartment building across the street from the person that you suspect has been ripping off the company. Okay, fixed point. Mobile surveillance: you're following the person around. Okay, in your car. Videography: using photography equipment. And increasingly, boy, it's this technology change, right? It used to be you have to have a big old camera or a big old video camera, right? Now you just, take an iPhone, boom. And then audio or electronic surveillance, wiretapping, or other sort of electronic surveillance, okay? Flying a drone over somebody's house. The drone thing is still in the courts. Got to determine what the limitations of that are. Generally, surveillance is legal, especially if you're watching someone in a public space. Can you have a suspect that your company is doing something bad at work? Can you follow them down the street? Yes, it's public space. Can you follow them into their house? No. Okay. Now, audio surveillance laws and regulations are more complicated depending on the state that you're in. For example, Illinois is not a one-party consent case. One-party consent would be if there's a phone conversation and one side says it's okay for you to record it, and the other side knows nothing about it. Okay, in a one-party consent state, it can be recorded. Illinois, all parties must consent to the surveillance. Okay, so you must inform the other party, hey, this is being recorded. That's why, for example, right now, if you look up in the left-hand corner of the screen, is that little red dot. That should alert people that this is being recorded. Okay. If sometimes telephone conversations, you'll hear an audible beep every few seconds. That's to tip you off that you're being recorded. Video surveillance, generally permissible, again, as long as you're not violating somebody's private exclusive control area. So you can't, go to somebody's bedroom window and stick a camera to look inside it. No, that's that. But can you be out on the street recording the person coming and going? I was talking with a fraud examiner who works for an insurance company, and dealing with cases of people that file for workers' compensation, saying that they were injured on the job and they can no longer perform their duties. And so they have to pay them workers' comp. And this one guy, he set up a video surveillance outside his house. And this guy would show up at compensation hearings in a wheelchair because he was injured. He could barely walk. Okay, so they did believe him. They set up mobile surveillance in a car outside his house. He comes walking out of the house, looking great, gets in his pickup truck, drives down the street. So they're following him along. He pulls up at a construction site for new houses. He gets out, and he's now, he was a roofer by profession, and he's carrying, big packages of asphalt shingles up to the roofs of these buildings, where he then, nails them in. Yeah, it's in public. You can record it. And again, it's become a lot easier with our technology. So you fire someone, or as they say here, discharge a suspected wrongdoer from employment. Now, a public employee like me, okay, has certain rights. So the public employers are governed by a stricter standard. Employer rights are dictated by the jurisdiction in which they operate. But for private employers in the United States, we're considered an at-will. Okay, you're employed at will. So if your company wants to hire you, they can. If they don't want to hire you, they can. They want to fire you, they can. Is that fair? I don't know. The flip side of it is, if you want to quit, you can. Okay, so we just as the employer can fire you at will, you can quit. You can't say, okay, that's it. I'm not. Now, if you say signed a 1-year contract and you've got certain special knowledge, you can have provisions that contract that say, no, if you quit, you can quit, but you cannot work for a competitor for 12 months, something like that. So, but generally, in the United States, it's an at-will employment situation. Employers, however, should document that they have good cause. Okay, so if you fire someone, as we tell people in HR, paper their file. Okay, put in reports that their misconduct was against written policy. It made the place unsafe or inefficient. And if you're going to fire someone, make sure the punishment fits the crime. Okay, maybe they took someone's yogurt out of the refrigerator in the lunchroom. I'm not sure that's a fireable offense. Okay, evidence should support questionable acts by the employee. Again, document. Nothing prevents the employee from then suing the employer in civil court, which is why, even if you're the employer and you're perfect legal grounds for firing the person, they can still sue you. They may lose, they probably will. In the meantime, you've got to hire a lawyer and go to all that expense. So best that you document that stuff so that disgruntled fired employee doesn't even try to sue you. So we talk about privileges. We talk about these: the attorney-client privilege, the attorney-work product privilege, the physician-patient privilege, the marital privilege, and there's some other miscellaneous ones. Attorney-client, my favorite, being an attorney, it's the right to not disclose confidential communications relating to the professional relationship. So the idea is we want people to be open and honest to their attorneys. Well, you can't be open and honest to your attorney if you fear that your attorney is going to turn around and, squeal on you, if you will. So, not only can you tell your attorney things, but it is, if say you came to me and hired me as your attorney, you told me that you did crime A, B, and C. And I turn around and call the police and say, hey, he just told me he committed crimes A, B, and C. I could actually be prosecuted. In most states, it's a violation of the law for a lawyer to violate the attorney-client privilege. There are exceptions. For example, if a client comes to me and says, oh, by the way, I planted a bomb in a bridge and it's set to go off, tomorrow morning. That I could report. And, hopefully that'll never happen. But crimes going to be committed that you can report. Okay. The client has right to compel non-disclosure. So the client can say, no, Mr. or Ms. Attorney, you are not going to disclose that. It applies only to communications intended to be confidential. So it's the sort of the elevator test. If the client tells the attorney something in a crowded elevator, well, obviously they're not really trying to keep it confidential. On the other hand, even you tell them in a restaurant, well, was it a booth at the restaurant? There are a couple of restaurants in downtown Chicago near the courthouse that have private booths where they can pull a curtain. Well, that's a conversation in there would be considered confidential. So it hasn't been intended to be confidential. It does not permit the attorney to conceal physical evidence. So if the client comes in and says, oh, here's the machine gun I used last night, no, you can't just hide that, okay? And does not apply again to future acts of crime or fraud. So I'm going to blow up the bridge tomorrow. Okay, no, the attorney should report that. All right. Now the work product, the attorney work product privilege, says not only is the communications with the attorney confidential, but anything that the attorney prepares, is part of, this defense or work is also confidential. So protects all materials prepared by an attorney in anticipation of litigation. It shields materials that would disclose the attorney's theory of the case. Any written materials directed towards preparation of a case and must be prepared in anticipation of litigation. So there has to have been some kind of a threat that there was going to be either civil or criminal litigation. Well, especially criminal litigation. Okay. Now this is where I've talked about this in other classes. I think I may have, mentioned it here. If a client comes to you, fraud examiner, and says, hey, fraud examiner, I need your help. I just defrauded a dozen people out of, $12 million. And let me tell you how I did it. Well, there is no fraud examiner client privilege. There is no accountant client privilege. Actually, in Illinois, there's a very thin carve out for an accountant client privilege. But it's such a thin situation, don't even consider it. So what should you do when the client comes and tells you that? I'm going to turn my camera back on so you see how serious this is. In that situation, you tell the client these two words: shut up. Okay. Then say, look, there is no accountant client privilege. There is no fraud examiner client privilege. You tell me something about you committing a crime. The police come to me and say, what did he tell you about the crime? I have to tell them. You can't compel me not to tell. Unless you hire an attorney right now. Take out your phone, call your attorney. If you don't have one, here's a list of attorneys you can call. You retain the attorney to defend you. Then you get the attorney-client privilege on that. Then you ask the attorney to hire me, hire me, the accountant or the fraud examiner, to assist the attorney in preparing for litigation. Okay? Then I am covered under the work product privilege. So then you say, I want you to hire my friend Bill, the fraud examiner, to help with this case. Okay, very good. Hands the phone to me, and I say, hello, attorney. Yes. So he has retained you to defend him. Okay, now you wish to hire me to assist in the defense. Very well, I will. And I will then bill you, Mr. Attorney, directly. I'm not going to bill this guy here. I'll bill you. Then you can turn around and include that in your bill to this guy here. Okay. So that's how an accountant or a fraud examiner can get covered under attorney-client privilege, by actually getting covered under attorney work product privilege, by getting retained by the attorney to assist in the case, to prepare documents for the case, work for the attorney. So again, I've heard cases of someone coming into an accountant and, talking about their crimes. To get that protection, stop them, and then tell them, hire an attorney, then have that attorney hire me as a consultant on the case and therefore, then you can tell the accountant whatever you want, because then you're covered under that attorney work product privilege. Okay. So remember that for the future. All right, going back. Physician-patient privilege. Again, we want people to be open and honest and forthright with their doctors. So confidential when obtaining treatment or being diagnosed, not just conversation on the golf course with your doctor. It has to do with medical stuff. When involved in litigation, the privilege is waived. So if then say you go to a doctor to be treated for an injury at work, then you sue the company, well, then the privilege gets waived and the doctor has to turn over the copies of the files, the medical files. Additionally, the privilege is waived if the court appoints a physician, say, to examine you to the extent of your injuries. Likewise, if you hire an expert witness, the privilege is waived. It's the other side, since they get to cross-examine your expert, they get to see what documents and what findings the expert had. The marital privilege, and this is different in different states. The first is the idea of spousal immunity. It protects a spouse from testifying against their own spouse. All right. If you have a spouse who's a defendant, it protects from adverse testimony by the other spouse. It's allowed in both civil and criminal cases. Covers statements made during the marriage. And every now and then you'll see a case where somebody's committed some crime and immediately, supposedly committed a crime, allegedly, immediately they go out and they marry their girlfriend or their boyfriend. And thinking that, aha, now, I told them everything I was doing. Now they can't testify against me. Not so. Most states, the statements had to be made during the marriage. They were made before you were married. Too bad. Though I've seen cases where they try to argue that because, again, depending on the state, they were living together as if they were husband and wife. And in that particular state, they have the law for common law marriage and said, we were, in fact, essentially husband and wife under the concept of a common law marriage. But usually you have to go through the ceremony, even if it's in the chapel in Las Vegas or whatever, in order to get covered under the privilege. But does not apply to crimes or to torts within the family, especially things like spousal abuse. It kind of be horrendous if a spouse were, I say if a wife was not permitted to testify as to the abuse they received from their husband, or a husband abuse they received from their wife. No, it doesn't apply there. Okay. Miscellaneous privileges. Confidential communications made to clergy. Very often it is called the priest penitent privilege. And the idea that coming out of Catholicism, that is, a person goes to confession, confesses their sin to their priest. And the priest can't then get hauled into the police station and ask, well, what did he tell you in the confessional? No, the priest has a right, and really there's the privilege not to say what happened. And it's been extended to all members of the clergy, regardless of religion, and communications with the people in their flock, if you will. Some states extend it to communications with regards to, say, statements made during a Alcoholics Anonymous meeting. Some states don't. Also depends, even with the doctor-client privilege, a medical doctor, yes. A psychiatrist, yes. A psychologist, generally, yes. What about a counselor, a marriage counselor? Again, different states have different standards on that. The government has a privilege that protects the disclosure of sensitive information. So information that's a national security interest, okay, they can prevent you from disclosing it. Trade secrets, you can be prevented from disclosing. Very often, if you're dealing in trade secrets, your employer will have you sign a contract that will, prevent you from disclosing it. And if you do, and then they can, they're entitled to, $10 billion or whatever. Again, there's no accountant-client relationship privilege. Little tiny one in Illinois. Better to get the attorney involved, as I mentioned before. So going back to the idea of Daubert versus Merrell Dow Pharmaceuticals, relates to the admissibility of expert testimony. Under the Daubert standard, factors that may be considered in determining whether the methodology is valid include whether the theory or technique in question can be and has been tested, whether it's been subjected to peer review and publication, whether it's known or has potential error rate, the existence and maintenance of standards controlling its operation, and whether it has attracted widespread acceptance within the relevant scientific community. And I am proud to say that when I worked again in federal court, we had a case in a criminal, actually a civil rights case coming out of a criminal case in which DNA evidence was brought in. And at the time, shows you how old I am, at the time, DNA was a whole new thing. Okay. And it was, in this case, that the DNA showed that this guy could not have been the killer. It was a murder case. Okay. And this guy was arrested. And he was never prosecuted, but then he sued the police, saying they should never have arrested him and charged him with committing this murder. Hello. Somebody turn the microphone on. Okay. And they brought in DNA evidence and said, see, the DNA shows that it couldn't have been him. And we were one of the first courts to ever allow DNA evidence into evidence, okay? Because they were able, in the opinion of the court, to meet the Daubert standard, okay? Because by then they had loads of academic papers and such that backed up DNA testing. All right. However, the guy lost the case because it was also determined that the police didn't have DNA back then, and this guy had acted very suspiciously, and there was a lot of evidence that gave them probable cause to think that he was the killer, which brings us to Module 3, probable cause. Again, in fraud examination, very often we talk about predication. It's very similar, probable cause. So in order to make an arrest, conduct a search, to obtain a warrant, whether a search warrant or an arrest warrant, in order to convince a grand jury to indict, okay? Last year, I was actually on a federal grand jury. Fun. And actually for 18 months, that's how long the term is. You don't go in every day, but anyway. And I cannot tell you anything more than that because you are sworn to secrecy. So probable cause, very important. And we talk about things like the culpability scale. So what is a witness? A witness is a person who is not suspected of being involved with the crime. Then you have the subject. So a subject of investigation may have committed unethical conduct, may be involved in suspicious activity, but they have not crossed the line to the point where their behavior is considered likely to be judged criminal. Okay, you're a subject, as opposed to a suspect, or in this case, the target. The target is believed to stand a better than 50% probability of being criminally charged with a crime. So that's the target of an investigation. So when we use those terms, that's what we're talking about. So with regards to probable cause, leading case right out of the box is Terry versus Ohio from 1968. The Supreme Court established that some brief seizures may be made without probable cause. That's known as a Terry stop. Stop. stopping a car. Okay, so you pull a car over and you go over and you talk to the driver. Well, what have you done? You seized their vehicle. You know, even they still are in it, but you stop them from proceeding down the street. But the court determined that, yeah, in certain situations, you can make, even without probable causes, this person committed the crime, you can stop them and talk to them. And remember, you don't have to respond. Okay, right to remain silent. Then in 1974, in U.S. versus Matlock, yes, that's the name of the case, the Supreme Court ruled that the co-occupant of a residence may permit a search in the absence of any other co-occupant. In fact, that happened apparently yesterday down in Arizona in the search for Savannah Guthrie's mother. They had this person taken into custody, okay, a person of interest, as they call them, and they went to where he lived. And he lived with his, apparently, wife and mother-in-law. And while they got a search warrant, they got to the residence, and the mother-in-law said, "Oh, come on in, I'll let you search." Well, as long as a co-resident or co-occupant allows the search, this search is okay, because you can search if you're given permission. Then coming out of our great state of Illinois, Illinois versus Gates, 83. Supreme Court lowered the threshold for probable cause by ruling that a substantial chance or fair probability of criminal activity could establish probable cause, and that a better than even chance of criminal behavior is not required. So, and the court doesn't like to get into percentages, but let's face it, better than even means over 50%. And so the court said, well, it doesn't have to be that high as long as there's a substantial chance. Well, what's that? 40%? 33 1/3%? They don't say, but there's a fair probability of criminal activity. All right. So if you're searching for or looking for documentary evidence, and again, documentary evidence is great because it doesn't change its story. Or really, any kind of evidence, voluntary consent. So in the case down in Arizona, the mother-in-law gave voluntary consent. Go ahead and search the house. Okay. Subpoena. That's, comes out of a grand jury or in a civil case from a court and just says, hey, we want you to turn over this stuff. Search warrant, however, allows them to come in and take the stuff. Advantages of a warrant over a subpoena: allows the holder to decide which documents are relevant. Okay. Avoids but does not eliminate the possible destruction of evidence. Okay, so the you give someone a subpoena, say turn over all of the the documents relevant to this fraud. Okay, I get to decide what's relevant and not. Search warrant, they come in and they just cart off your file cabinets. Okay. A subpoena, they could say, hey, we got subpoenaed, we got these incriminating documents, shred them. A search warrant, they come right in, and again, the FBI gets a search warrant, they come in and they take the computers, they take the all the hard drives and flash drives, and take file cabinets full of documents. Another is you interview key witnesses without opportunity to prepare. So a subpoena, they give you, it takes time. You have an opportunity to prepare. Warrant, they can just grab the stuff and start questioning. So types of records that can be seized with a search warrant: any property that constitutes evidence of a commission of a criminal offense. So the judge signing off on the warrant will say, okay, have you detailed what property are we talking about here? That can include contraband, the fruits of the crime, or things otherwise criminally possessed. So if somebody committed a fraud And they went out and they bought, we had one case in Chicago, they bought a whole bunch of luxury cars with the proceeds from this fraud. So they got a warrant, and I had a friend who was working with the Secret Service on this one, and they found this garage where they were stored, got the warrant, went in and drove off in all of these luxury cars. They really enjoyed it, driving a Maserati back down to Secret Service headquarters. And DEA does that a lot for drug suspects, because very often they, buy fancy, flashy cars. And there's a garage downtown Chicago that the Secret Service and the DEA maintain where it looks like a car show. I could tell you where it is, but then I'd have to kill you. No, I'm not telling you where it is, but I know where it is. So all those things can be seized with a warrant. Property designed or intended for use, or that have been used as a means of committing a criminal offense. And again, in fraud cases, that can be your computer. All right. Rules of evidence. Evidence must be relevant and trustworthy. It must be admissible in court. Testimonial evidence is, testimony on the witness stand is evidence. And testimony in the form of a signed sworn affidavit is also evidence. We talk about real evidence versus demonstrative evidence versus circumstantial evidence and direct evidence, and we talk about the facts that are at issue or in dispute, okay? So, real evidence. What's real evidence? Real evidence speaks for itself, or as we say in Latin, res ipsa loquitur. The thing speaks for itself. So it must be authenticated, okay? So if you have a weapon that's been found, as long as somebody can come in and find, testify as to where it was found, or a video showing something, well, you bring in, person that had the custody of the video equipment and testify as to the authenticity of it. Demonstrative evidence purports to educate, summarize, or amplify real evidence. So let's say in a courtroom, you prepare, say there's a street shooting. So you prepare a little model of the buildings and the streets and the cars, or even in an auto accident, you create a chart showing where the cars were coming. This car was coming from this direction or that direction. That's demonstrative. It tries to educate or summarize. In fraud cases, very often we'll have, an accounting statement, okay, or some sort of a prepared summary of the losses, okay, prepared to educate, to summarize, rather than have the jurors read through, 150 pages of accounting records. We can summarize it, okay, in some sort of an accounting record. Again, it should tell a story or complement other evidence. It must not create prejudice. And again, in most fraud and forensic accounting investigation, this sort of demonstrative evidence is often at the heart. 5, documentary evidence considerations. The document must not have been forged. No. We don't do that. If you're dealing with a document, so if you're presenting a document in court, number one, do not have a forgery. And by the way, there are document experts. So if you suspect a document might have been forged or a signature on it might have been forged, you can bring in an expert who can testify as to it. I had a case where I was called as a signature expert because I've been dealing with this stuff for a long time. They settled just before I was to take the witness stand. Maybe I scared them. I don't know. But there was one case where the typeface on a typed document, they had a typewriter expert who was able to testify that typeface did not exist on the date that this document was supposedly created. So don't forge things. Original documents are preferable. If an original document is available, you should be using that. The document must not be hearsay or objectionable. We'll get into what hearsay is in a bit. The document nonetheless needs to be authenticated. Yes, you bring in the file clerk from the corporation who's able to testify that, yes, those are the invoice files for this company as of that date. And it must be reliable, okay, that you can rely on it. That's a pretty basic term. So the best evidence rule allows copies to be presented at trial under certain circumstances. So sometimes you can't get the original document. Okay, you have a reason to believe it's been destroyed, or even such things as a birth certificate. The original birth certificate might be in the files of the county clerk. You can get a certified copy, but they're not going to release the original. So best evidence rule, you're allowed to provide a copy. Chain of custody refers to those individuals who have had possession of physical evidence and what they did with it. In civil litigation, most of the discovery work is done through copies transferred among the parties. So right at the beginning of civil cases, we say, okay, look, we will get the original documents. We will store them in a safe or store them in a secure location so nobody can get at them. So, and then we'll have a logbook. When we take a document out and make photocopies, we'll log that it was taken out to make copies, and then we will log when we put it back in. I had a case I was involved with involving asbestos in very many locations. We took out the entire floor of an office building downtown Chicago and secured it. You had, tap in a code to get in and log in that you were going in and record what document you were pulling out, etc. And then eventually we scanned all the documents so everyone could get scanned copies of it. A chain of custody is important because you don't want people getting that original and then forging something on it. Okay, so generally the chain of evidence, chain of custody, does not normally play a central role in civil disputes, but sometimes it can. Yes. Testimonial evidence, okay, people testifying at trial, brings about the discussion of hearsay. What is hearsay? Well, it's what the words say. I heard someone say blah, blah, blah. They heard someone say something outside of the courtroom. Well, problem is, remember, you have that right to confront someone testifying against you. Well, if that person said something outside the courtroom, well, then you call that person in to testify, and then you can be cross-examined. Oh, but I don't know who that person was. I just heard them say that. Nope, it doesn't come in. So if, say there's an accident scene, say this is an auto accident, and you put someone on the witness stand who was there and say, well, I didn't see the defendant run through the red light, but I heard someone say that they did. Objection, Your Honor, hearsay, sustained. That's hearsay. Juror is instructed not to consider what was just said. No, you need someone, since you have to be able to cross-examine them, you don't allow hearsay in. So each person must testify based on his or her own first-hand experience. There are exceptions. If the truth of the statement is not at issue and it does not impact actual guilt or innocence. Okay, so let's say the auto accident case, and the guy, this bad accident, guy, falls out of his car, is on the pavement. The question at issue, okay, is, was he conscious when he hit the pavement? And your witness says, yes, he was conscious. Well, how do you know that? Well, because he said, I'm so sorry that I was driving so fast down the street. Now, is that admissible or is that hearsay? He heard it said as being admitted to court, but the question at issue is not, was he speeding? The question at issue is, was he conscious? Well, the evidence showed he was conscious because he was able to talk. So it's admitted, and very often the judge would give an instruction to the jury to say, okay, jury, you're allowed to admit or to accept this evidence, but only as to whether or not the guy was conscious, not as to the truth of what he was saying about speeding down the street. Okay? Sometimes a court would say, that's just too prejudicial. All right. But anyhow, it has to go to this idea that it's the question at issue. The question at issue is whether he was conscious, not whether he was speeding. Statements against your interests are generally admissible. So in that case, if the defendant was the one who said that on the street, hearsay does not apply. He's the defendant. He said something against his interests. Yeah, it's a statement made outside of court, but it was a statement made against your own interests. That's allowed in. That's a hearsay exception. Also allowed in business and government records. I was saying, like birth certificates. We don't bring in the Secretary of State to talk about your driver's license or whatever. The record is allowed in. Or the absence of an entry in a business record. Recorded recollections are allowed in. So, for example, if after your boss comes into your office and tells you all about a massive fraud that they're running, and you immediately write down all the details after he leaves your office. Okay, that is a contemporaneous recorded recollection. Okay, so you're writing down what your boss said immediately after he said it to you. Later, the case goes to trial about this fraud, and the boss is trying to make you look like the one pulling off the fraud. But I've got this statement that the boss said to me, hearsay. No, that was a contemporaneous recorded recollection. It's allowed in. So that's brought in. Former testimony. So if you testified in a different case under oath, statements made under oath in other cases can come in. The present sense impression. Okay, you're just, you're not asking for the truth of what they said. Just what was your impression of them? I don't want to know what they said, but were they in a rage? Were they calm, etc.? Tied to that, the then existing mental, emotional, or physical condition of the person. Statements made to medical personnel. So again, they're taking the person to the hospital in an ambulance, and the guy starts talking to the paramedic about what happened that caused the accident. Also, printed matters, learned treatises, and refresher writings. So again, if you had notes from that conversation with your boss and you are brought to the witness stand and I don't remember exactly what he told me, but I have some notes. Can I refresh my recollection with them? And the court will say yes. And then you read them over and say, now I'm prepared. I can say what he told me. That's hearsay. No, because it's a statement against the defendant's interests. Anyway, there are whole courses in law school covering this. So, don't worry, you don't know all the fine points. So let's talk about our criminal justice system. Most cases never end up in the criminal justice system, or at least all the way to the end. So 3 routes that a target may enter, where you enter into that criminal justice system. The police arrest you on the street. They saw you do something or whatever, the warrantless arrest based on probable cause. Or there's an investigation and the prosecutors file with the court an information. Okay, that's a charge. Not an indictment, but it's a charge against you. You're still charged with a crime. The third way, the grand jury is called in, and the grand jury is, asked, we believe we have probable cause for you to indict this person. The grand jury only determines whether or not there's probable cause, doesn't determine, guilt. And if they feel that there is probable cause, then the grand jury will indict. They had a case out of Washington just now where these members of Congress who made this videotape telling members of the military that they don't, they are not to follow illegal orders. The U.S. Attorney Gene Pirro tried to indict them in Washington, and the grand jury in Washington refused to indict. So citizens get to determine whether or not indictments are issued. Once an indictment, sometimes also called a true bill, is issued by a grand jury, it's given to a judge who will then issue an arrest warrant. Criminal laws and criminal cases must be brought without unnecessary delay. However, the defendant can ask for additional time to prepare their defense. That usually is what delays things. We did have that one case in Chicago with the gentleman who was accused of putting a hit out on the head of Customs Border Enforcement or whatever, and Mr. Bovino. And usually a case like that would be months before it went to trial, except their strategy, defense strategy, was no, let's take it to trial now. And they did. And it was only weeks after the incident that brought about the charge. And it was, so that's very unusual. Usually, the defendant will ask, Your Honor, I'd like additional time to prepare my defense, and it's granted. But if they say we're ready to go to trial, the prosecution has to be ready to go to trial. If they say we're not, we want another 6 months, the court will dismiss the case. All right. Going on. There has to be sufficient evidence to bring the case to trial. Again, the indictment is where a grand jury finds probable cause, and the defendant is then officially charged. Very often, the indictment stage is combined with the arraignment. The defendant is brought in, and in court is formally informed of their crime and charges against them. They are advised of their rights in open court, and then they're asked to enter a plea. And their choices are A, guilty, B, not guilty, or C, nolo contendere. This says for all practical purposes, a plea of guilty. It's basically saying, I am not going to plead guilty, but I'm not going to fight the charge either. Okay. Maybe for whatever purpose, for your own integrity, you're not going to plead guilty, but you're essentially going to be, punished as if you had pled guilty. Then, in most cases, you have a choice. Some small, cases, you're only entitled to a bench trial, but for most cases, you do have the option of asking for a jury trial. But you can waive that. You can say, I just want a bench trial. I just want a judge. I think I can win without the jury. Fine. In which case, you get a jury trial, the judge is still there and decides matters of law. But as we like to say, the judge decides matters of law, the jury decides matters of fact, of whether or not the evidence is sufficient to prove a fact. You can have various defenses, and even saying that there were mitigating circumstances for what I did. Maybe I did do the wrong thing, but consider the circumstances I was in. After the verdict, a convicted person may appeal the verdict. Can immediately appeal, or stand for sentencing, or appeal after sentencing. Okay. And then you can be incarcerated. If it's less than a year, they send you off to jail in Cook County Jail. If it's more than a year, then you're handed over to the Illinois Department of Corrections and sent to prison. And our prison system, we have community-based programs. There are minimum security prisons, minimum, medium, and maximum security. I know the federal government up in Duluth, Minnesota, has a minimum security camp next to an Air Force base. And those who go there, they do things like landscaping at the Air Force officers' golf course. And the camp has no walls, but there's a big, stripe painted around the camp, okay, on the road. And the prisoners are told, the convicts are told, if you cross that stripe, you will be considered escaping from the prison. And escaped prisoners are then sent to a maximum security prison. And you don't want to do that. I tell you, one of the nice things being an accountant, if you're an accountant and you get convicted of a fraud case, generally they'll send you off to a minimum security place because, one, they're cheaper. And so, and you're really not a physical, violent threat to anyone. So there's another good reason to be an accountant. Parole means you during your time in prison, you've been acting good, acting honorably, you're helping out, whatever. We're going to let you off for good behavior. Probation says we're not going to send you to jail or to prison. We're going to just let you go. We're going to keep an eye on you. And if you screw up, you'll be back here, within a year or 2 years, whatever, or 6 months, whatever the term of probation is. You'll be back here, and then we will sentence you, or send you off to jail. Recidivism is the idea that very often folks get convicted and sent to prison, and very often in prison, they learn how to be better criminals. And so they're released, and then they commit crime again, and then they go back again, and then they get released, they commit. So it's that vicious circle. Again, the prosecutors have discretion as to whether or not to prosecute, and if to prosecute, at what charge. And do not forget that businesses and other organizations can be prosecuted. Now, we can't take a corporation and put them behind bars, but we can take their money and their property. And as I said, like if you're a defense contractor and all your contracts come from the federal government, you can be debarred. Okay, that's not disbar. Disbar is when an attorney loses his law license. This is debarred, and that's when a company is told you can no longer get contracts with the government, and it usually puts them out of business. Okay. The civil justice system, again, government prosecutes criminals on behalf of society, but private parties can also go into the court system and attempt to right a wrong, resolve a dispute through the civil justice system. And fraud is just one such wrong that may enter the system. So it could be torts, breach of contract, breach of implied contract, negligence, misrepresentation, et cetera, et cetera. Again, your business law course went into all these things. Primary purpose of civil action is to recover losses and possibly, in some cases, get punitive damages. Jurisdiction. Most civil actions are handled in state court in the jurisdiction of the plaintiff or the jurisdiction of the defendant. Federal court can get larger cases, but they have to involve more than 75,000 75,000 or multi-jurisdictional. There's a whole bunch of rules on how a civil action can get into federal court. But if you've got a defendant in one state and a plaintiff in another, the idea is that the state courts of one or the other states are going to favor that person more. So we'll take it to a federal court where hopefully they'll get a fairer trial. But it has to be above 75,000. All right. So a civil suit begins with a complaint. So the plaintiff, thus the name plaintiff, see, complaint, plaintiff, files a complaint in court. And again, if it's fraud cases, the rules of procedure state fraud must be specific. Why? Ooh, I love it when I hear my own voice. Because fraud is so easy to allege. So you better spell it out, okay? It must be brought by, impacted by a damaged victim, okay? And show how the misrepresentations were false. All right. You must show that something was misrepresented, I was injured, and they were false. Now, normally the defendant, once the complaint is filed, the defendant will then look at the allegations in the complaint and answer, usually saying, I deny, I deny, I deny. Okay. But then they can also add a counterclaim against the plaintiff. And in fact, not only did I not do these things, but the plaintiff did a bunch of bad stuff, and I'm suing the plaintiff. Okay. So we got a counterclaim. All right. So the parties are here. The parties, the issues have been met. Okay. Now they're allowed a period of discovery to go out and find the facts and find the evidence in order to bring a good case into the courtroom. They can include interrogatories. An interrogatory is a set of written questions that you serve on the other side and say, answer these questions. They could be such things as, what's your name? Were you, the owner of a 1999 Ford pickup, yes or no? Were you driving that vehicle on, June 12th, 2021, and, et cetera, et cetera. Okay, it's just answering questions. Now, you can also serve the other side with a request to produce documents. We want to see a copy of the contract that's in dispute. Okay, so produce documents. There are also depositions that say, okay, I want you to come into my lawyer's office where there will be a court reporter there. You will be sworn under oath to tell the truth, the whole truth, and nothing but the truth. And then you'll be asked questions by my lawyer. Your lawyer can be there to object if there's something objectionable. And then the whole thing will be recorded, and the transcript of that deposition that you swore it was true can be used later on in court. There can also be requests for admissions. So do you admit that you were driving the 1999 Ford F50? I don't know if they're making them back then, but on this date, yes or no? So request for admission. All right. So some discovery can cost a lot of money. It can last for a long time. So sometimes at the beginning, sometimes at the end, sometimes even before the complaint is ever filed. Okay. What will sometimes happen is if I've done this, if a client comes to me and says, I want to sue this person because of this auto accident. Okay. Well, then I, being your attorney, I will take a lien on the eventual award in this case. Attorneys very often charge a third of whatever is recovered. Okay, so I have a lien. So rather than start off by filing a complaint, I will send the other side a letter saying, I'm putting you on notice that I have a lien as to the claims of my client against you. It might be helpful if you notify your attorney and send them this letter. They give it to their letter. They give the letter to their attorney. Their attorney calls me and we say, so what do you want to do? Should I file the complaint or can we settle this thing now before we get into all that? Very often, a lot of cases get settled right then and there. Or you're told, send this letter to your attorney and or insurance company. At that point, I get a call from an insurance claims adjuster who says, okay, we got your letter. We know about the auto accident. Let's see if we can settle this thing before we have to go to court. Bingo. Okay. But if that doesn't work, then I file the complaint. The court says, okay, we're going to start discovery. And then the attorney on the other side or the insurance company says, let's see if we can settle this thing. All right. Out of court settlements, both sides, we come to a settlement position. The attorneys negotiated. Everybody walks away, usually unhappy, sometimes happy. Okay. Sometimes we say, all right, especially if there's complex issues, let's bring in a mediator. Independent third party has no authority to decide the case. They assist both sides and see if we can work out a mutual agreeable resolution. Okay. So it's, just like, see if we can just work this out. Let's bring in a mediator, see if, what will work out. Very often, that works. Okay. Then there's arbitration. An independent third party who acts as judge and jury. They have the authority to determine the outcome of the case. They can actually have a binding verdict that says whatever the arbitrator determines, it's binding on them. They can't then turn around and go back to court. Now, non-binding verdict means they can then go to court. I'm going to guess that every one of you out there at some point has witnessed an arbitration hearing, because if you've ever watched a program like Judge Judy, People's Court, what have you, those are arbitration hearings. These people have filed, you see on that show, they filed a lawsuit. The folks, the producers of Judge Judy and Judge Mathis and all these others, they have people that go into the courts. Judge Mathis was filmed in Chicago. They had people down the circuit court of Cook County going through the cases that were getting filed, and they found something particularly juicy. They would then have their people contact the parties and say, hey, what do you say you dismiss your case in Cook County and have Judge Mathis determine it for you? And they do, and then the production company comes up with the money that then gets awarded. But that's an arbitration. Judge Judy, Judge Mathis, they're independent third parties. They acting as a judge, determining the case. And they're binding. They can't then run to court. Then you have pretrial motions and the civil trial. Again, before you go to trial, if settlement fails, you do things, with pretrial motions. We'll talk about those. Next slide. It can take months, if not years, for civil action to actually be heard in a court. Again, difference between civil and criminal trials. One is the speed. All right. Again, criminal trials must be, brought along with all deliberate speed. Again, this differs a bit amongst the states, but very often a civil trial will have a jury of only 6 people. The attorneys agree. You don't need a unanimous verdict. You need that in a criminal case. The civil verdict does not require a beyond a reasonable doubt. It only requires a preponderance of evidence. And after the loss, if there's a judgment entered, then the winning party of a civil case can have post-judgment discovery where you go out to find the money to collect on that judgment. I've done that. Well, I had one guy, I got a big judgment against him. He tried to not pay by moving his money out of the bank he had his checking accounts in to another bank. I was able to find it. And I went to court and got an order for that bank to seize the money and hand it over to me. He was not happy. Okay. So pretrial motions, you have all sorts of things. A writ of attachment that prevents defendants from disposing of the asset. All right. So the court says, hey, while this thing is pending, you can't go selling that, boat or car or cashing out the money, whatever. Sequestration, in which the court takes possession of the asset. Says, okay, bring the car over to the court and the county sheriff will hold it in their garage. Motions for injunctive relief to prevent a defendant from transferring or moving assets. A motion to dismiss, saying, look, there's no basis in the law for this lawsuit. Motion to make more definitive and certain. Motions in limine that prohibit reference to a prejudicial, should be matter, not mat. Okay, so Let's say the guy is a no good bum. He's been arrested many times for I don't know what being drunk, public intoxication. Okay, none of that comes in because it has nothing to do with this case, but it would make him look bad in front of the jury. Okay. Motion to strike inflammatory, prejudicial, or irrelevant material. Motions for continuance to postpone a hearing or trial, or a motion for summary judgment. And that takes place when at the end of discovery, you go to court and say, Your Honor, we have all the discovery here. It's obvious that they have no defense to all this, and therefore we don't need a trial. Just go ahead and enter judgment. Okay. Now, here's the chapter I'm going to essentially skip over because you should all know this. Okay, basic accounting principles. So I look at that. Balance sheet, income statement, statement of cash flows, accrual. Accounting. All right, we know about that. There's your, the flow through the books and records. Again, if you don't know this stuff, go back and look at these slides, but every one of you should know this. We have different ratios that we look at for performance assessment, decision making. Actually, these next few charts are, you may want to, all the PowerPoint slides are on Blackboard. You may want to print these out because it's a real nice summary of ratios that you're probably talking about in other classes. So here are your liquidity ratios, and there they are. Here are your operating efficiency ratios. Here are your operating profitability ratios. Again, these are really great little slides with all this, summary information. Again, all the information going into it comes out of the accounting records. Whoops, missed my arrow here. The business risk or the operating ratios, financial risk or leverage analysis ratios. Okay, so I got through a whole bunch. So now let's talk about the regulatory system. Okay. So we'll talk about each of these bullet points in the next few slides. Okay, the first one, AICPA, American Institute of Certified Public Accountants, and its statement on auditing standard number 99. Okay, again, this is an auditing standard for non-public companies, since auditing standards for public companies is taken care of by our friends at Peekaboo. Okay, the Public Company Oversight, Accounting Oversight Board. So, again, the standard reasonable assurance, you require reasonable assurance and professional skepticism. So they got, we'll talk about auditing 99. AICPA issues auditing standards for auditing a non-public company. They still have stock and shareholders, but they're just not sold really publicly, in that case, in interstate commerce, because then it comes under federal jurisdiction. We have standards for auditing. The AICPA also issues standards for compilation and reviews, other sorts of attestations, consulting, and they also have the Code of Professional Conduct. Specifically here, following the Enron case, AICPA issued SAS number 99 that says an audit is performed to ensure the financial statements are fairly presented and free from material misstatement. However, additionally, the auditing standards require that an audit be completed with due professional care. What does due mean? Due process. Due simply means appropriate. So the appropriate level of professional care. Okay. We know that fraud can arise from one of two sources: a misappropriation of an asset that rises to the level of materiality. So if people steal stuff that, that's valuable enough that it goes above the materiality level for the audit, or material financial reporting fraud. Okay. They played with the numbers in the books. Right? They cook the books. The ACFE, the Association of Certified Fraud Examiners, lists three sources of what is defined as occupational fraud. Again, remember, asset misappropriation, fraudulent financial statements, and corruption. All right. Again, AICPA says when you conduct an audit, you have to have professional skepticism. An attitude that includes a questioning mind and a critical assessment of audits. The conduct of an engagement, it recognizes the possibility there might be material misstatement because of fraud. And we have to be dissatisfied with less than persuasive evidence. Excuse me. One more time for a little drink. We'll talk a bit about the fact that white-collar criminals exploit your humanity, but you as the auditor, Ronald Reagan said this in dealing and negotiating with the Soviet Union. We trust you, but verify. So when they're doing an audit and they tell you something, that's great. Now show me the document. Okay. White collar crime is a crime of deceit, and the criminals are artful liars. So again, after the fraud of the Enron scandal, SAS 99 came out and said, okay, going forward, we are going to have an 8-step approach. And here are the 8 steps. Okay. It said at the outset, the beginning of an audit engagement, the auditors should undertake a staff discussion. Okay. Bring them all together. All the auditors are going to work on this audit. We'll bring it together. And the term that we use is a brainstorming session. We sit around, we talk about the company, say, okay, now, if someone was going to commit fraud, how it would be done and who would be doing it? And then determine, okay, if that was happening, what would be the red flags that we should be looking for? And then in preparing the audit and performing the audit, we look to see if those red flags are there. So step 1, brainstorm. Step 2, gather information necessary to identify those fraud risks, the red flags. Step 3, the auditors attempt to identify risks that may result in fraud. Step 4, the auditor assesses the fraud risks after consideration of programs and controls to prevent fraudulent financial reporting. 5, the auditor develops specific responses to the fraud risks. 6, consider the audit evidence. Require auditors to continually be thinking about and assessing fraud risk throughout the audit. Step 7, the auditor then communicates the findings with regards to fraud. And step 8, document each step. So in your audit work papers, document that, yeah, you had the staff meeting. We spent half a day, we spent all day, we spent 3 days brainstorming about fraud, and this is what we came up with. And then all those other steps as well. So how do you communicate? You communicate anything with regards to fraud to an appropriate level of management. Anything dealing with management fraud. So if it isn't just somebody down on the factory floor, if it's management involved in a fraud, you bring it to the audit committee. And again, I've chaired audit committees, and that's always fun. A material fraud to management, and all material fraud goes to management and the audit committee. So if it's a material number, take it to management, but also take it to the audit committee. And if the reportable conditions related to internal control environment have been identified, again, there's some sort of internal control problem here that's allowing this fraud, also communicate that to the audit committee. So what do you document? The staff discussion. Information used to identify the risk of fraud. The fraud risks that you identified. The assessed risk after considering programs and internal controls. The results of assessment of the fraud risks. The evaluation of audit evidence, and then document those communications as well. And then, again, I'm not showing the picture because I was like 50 pounds heavier, but I met Senator Sarbanes and Congressman Oxley. And back in 2002, the Sarbanes-Oxley Act was passed by the House and Senate, signed by the President. It created a higher standard for corporate governance and accountability, created an independent regulatory framework, enhanced the quality and transparency of financial reports, imposed severe civil and criminal penalties for corporate wrongdoers, and put in new protections for whistleblowers as well. Then, empowered by Sarbanes-Oxley, the SEC was told implement. Okay, so the SEC issued new standards of professional conduct for attorneys. So if you're going to be messing in the securities world, attorneys, we got new standards for you. Also, standards and procedures related to listed company audit committees. You audit committees, you got standards for you too. Strengthening the commission's requirement regarding auditor independence. That was good stuff. A lot of audit firms got a little problem with that. Disclosure and management's discussions and analysis about off-balance sheet arrangements and aggregate contractual obligations, and disclosures regarding a code of ethics for senior financial officers and the audit committee financial experts. Again, they wanted to make it a requirement that you have an accounting professor on every audit committee, which would have been great. There's not enough of us go around, so they said, okay, you need a financial expert. Yeah, okay. And they have a code of ethics for them. All right. So rules included retention of records relevant to audits and revenues. In the Enron case, you had the Arthur Andersen auditors having a shredding party where they shredded lots of documents. No more. Rules regarding insider trades during pension fund blackout periods where, you can't trade those funds involved with the pension. Conditions for the use of non-GAAP financial measures and certification of disclosure in companies' quarterly and annual reports. All these implemented in order to implement the Sarbanes-Oxley Act. Okay, and I'm just gonna, roll through. Here's a big old listing of the provisions of the Sarbanes-Oxley Act of 2002. Right at the start, 101 established PCAOB and listed what it does, and going on to all of these different standards and provisions. You can see just at the list. It's a very nice comprehensive list of Sarbanes-Oxley Act, known lovingly as SOX. And I'm going to fly through them because I'm losing my voice again. Okay. Additionally, and this one got a lot of CEOs ticked. Sarbanes-Oxley said the chief executive officer and the chief financial officer of public companies must personally certify the annual and quarterly SEC filings. And CEOs were like, wait a second, I can understand the CFO signing off. They should know this stuff, but I'm a CEO. My background is in engineering or science or whatever. I don't know accounting. And basically, the SEC said, oh, well, that's too bad. You better learn accounting and learn it fast because you've got to sign off and personally certify the 10K, the annual report. And so these certifications essentially require CEOs and CFOs to take responsibility of the company's financial statements. There are two types of officer certifications mandated, the criminal and the civil. So yeah, you could go to prison, okay, if you certify and you knew, it was bad. So Section 906 said periodic filings with the SEC must be accompanied by a statement signed by the CEO and CFO, which certifies that the reports comply with the SEC's periodic reporting requirements. And these certifications are known as the criminal certifications because the Act imposes criminal penalties on officers who violate the certification requirement. And that's basically comes down that you knowingly knew that it was wrong and you certified anyhow. Okay. Now, the one that often catches them is Section 302. Okay. That is a little more detailed. Okay. You personally review the report, and based on your knowledge, the report does not contain any material misstatement that would render the financials misleading. Also based on your knowledge, the financial information is the report fairly presents in all material respects the financial condition, results of operation, cash flow of the company, and that you, the CEO and CFO, you're the ones responsible for designing, maintaining, and evaluating internal controls, that you have disclosed to the auditors and the audit committee any material weaknesses in those controls and of any fraud. And you, CEO and CFO, have indicated in your report whether there have been any significant changes in the company's internal controls. You violate any of those, you get sued big time. All right. So management's assessment of internal controls, section 404 of SOX, requires that all annual reports contain an internal control report that states, 1, management's the one responsible for establishing and maintaining internal controls, and 2, contains the assessment as to the effectiveness of internal controls. Okay. The filing company's independent auditor will also issue an attestation report on management's assessment on internal controls. So we're kind of watching each other. Other things, 301 requires the audit committee for each publicly traded company to be directly responsible for appointing, compensating, and overseeing the work of the company's outside auditors. In the past, not so much. Sometimes the CEO was the one essentially hiring the auditors, and the audit committee, if they had one, or the board just signed off on it. Okay. Each member of the audit committee must be a member of its board of directors and must otherwise be independent. Cool. See, that got me immediately onto boards of directors. Section 407 of the Act required public companies to disclose whether or not the audit committee has at least one member who is a, quote, financial expert, and they must establish a hotline for complaints and anonymous employee tips regarding irregularities, and those tips come to the audit committee. Other things, you establish a list of activities that public accounting firms are now prohibited from performing on behalf of their audit clients. We'll talk about that in the next slide. Require public accounting firms to rotate the lead audit partner or the partner responsible for reviewing the audit every 5 years. Originally, it was wanted, the original Sarbanes-Oxley Act, they wanted to have firms change the audit firm every 5 years. Let's face it, because of Sarbanes-Oxley and everything else, we only have 4, the big 4 firms that do the biggest corporations. So every year we're running it around to another firm, and that is a big startup cost. So they said, okay, we'll compromise. You just have to change the partner in charge of the audit. And then, okay, and the reviewing partner too. Okay, fine. Okay, so it makes it unlawful for a public accounting firm to audit a company if, within the prior year, the client's CEO, CFO, controller, or chief accounting officer worked for the accounting firm and participated in the company's audit. Very often happen. The partner in charge of the audit leaves the accounting firm, becomes the CFO of the corporation. And now it's like, nope, can't do that, at least not for a year. Take a year off, go on vacation. When you come back, we'll think about hiring you. Okay. Also requires that the auditors report directly to the audit committee and not, to the CFO. You talk to me. Again, I love that as chair of an audit committee. So if you're an accounting firm and you're providing a corporation with audit services, you are not allowed to do bookkeeping, because then you're like auditing your own work. You can't do financial information system design and implementation, which was a huge blow to the big accounting firms. They made a lot of money off of putting in IT systems for their audit clients. And they were told, no, can't do that anymore. Can't do appraisal evaluation services, fairness opinions, contribution in kind reports, actuarial services, internal audit outsource service, management function. They used to do all this stuff. It was like, your audit firm is your one-stop shop. We'll audit you. We'll also do your human resources. We'll do management. I worked for Arthur Andersen for the summer, they would do, headquartered in Chicago before they went bust after Enron, they even had a department that would do landscape architecture. Okay, this idea they do everything. They did broker-dealer services, legal services, okay, or any other service the PCAO will be prescribed. The only thing you could do is still do tax services, because that's kind of too closely entwined with the accounting. So you can provide tax services, that's it, nothing else. Every annual report must contain a report on internal control, and it makes it unlawful for any officer or director of a public company to take any action to fraudulently influence, coerce, manipulate, or mislead an auditor in the performance of the audit. Enhanced financial disclosure requirements. Again, if you have off-balance sheet transactions, they had that in Enron, and that's why they say, got to report that. You direct the SEC to issue rules on pro forma financials, makes it illegal for public companies to make personal loans or otherwise extend credit to or for any director or officer. That bummed me as a director. Yeah, you can't give me a loan. Establishes disclosure requirements for stock transactions by directors and officers or persons who own more than 10% of a publicly traded company. So if you're one of those, you have to file, if you have stock transactions with that company, to file a report with the SEC. SEC established rules that require public companies to disclose whether they've adopted a code of ethics for the senior financial officers. Good idea if you do that. Require the SEC to make regular and systematic reviews of disclosures. Public companies must publicly disclose information concerning material changes in financial condition and operation. Establish broad new protections for corporate whistleblowers. Create civil liabilities for companies that retaliate against whistleblowers, and makes it a crime to knowingly, with the intent to retaliate, take any harmful action against a person for providing truthful information relating to the commission or possible commission of any federal offense. If you're at a company and you see something bad going on and you want to be a whistleblower, please find an attorney who knows this stuff and talk to them. They will walk, because there are specific steps you have to take. Okay. Can I just go and talk to the Wall Street Journal? No. Talk first to the SEC or to the state attorney general or whatever. Okay. That's the better way of doing it. SOX enhances criminal penalties for a number of white-collar offenses. It amended the mail fraud provision of the U.S. Code to make an attempt and conspiracy to commit offenses subject to the same penalties as the offense itself. So even if, hey, I didn't get away with it, I didn't do it, but you tried to, and you conspired to, you still go to prison. Amends the mail fraud and wire fraud statutes to increase the maximum jail term from 5 years to 20 years in prison, and makes securities fraud a crime, providing fines up to $250,000 and up to 25 years in prison. Also, the act makes destroying evidence to obstruct an investigation or any other matter within the jurisdiction of the U.S. Department, of any U.S. Department, illegal and punishable by a fine up to $250,000 up to 20 years in prison. So be very, very careful if you've been told that any federal agency is investigating you. Do not destroy documents. SEC can petition a federal court to issue a 45-day freeze on extraordinary payments to any of the foregoing persons. We're talking officers, directors mostly. Amends the bankruptcy code so that judgments, settlements, damages, fines, penalty, restitution, and disgorgement payments, I love that term. They say, like, you got paid a bonus, we want it back. We're going to disgorge the payment out of you. Resulting from violations of securities laws are non-dischargeable. So it's like, oh, I can't pay that, I'm filing for bankruptcy. Fine, file for bankruptcy. When you come out of bankruptcy, we're still going to ask for the money. If a publicly traded company is required to prepare an accounting restatement due to the company's material non-compliance as a result of misconduct, any bonuses you got must be disgorged. So if you got a bonus because your company reported this great earnings last year, and it turns out they were wrong, you got to send the money back. So keep some money in the savings account. Then it created the PCAOB. Okay. So if you want to do an audit, if your firm wants to audit publicly traded companies, you have to register with the board. And it is an onerous process, which is why the number of accounting firms that audit publicly traded companies has dropped, and it's sort of consolidated in the Big Four. And then maybe the next 20 accounting firms after that. A lot of accounting firms still do non-public companies, but the public companies, it's really only the top, because it's become the entry fee, if you will, to audit them has become very high. The PCAOB has issued its very own auditing, quality control, and independence standards and rules. They inspect those registered public accounting firms. They have inspectors that investigate and discipline you. And who did they hire at the first cut to be their inspectors and their investigators? They hired auditors who had been fired from their big, back then, Big 8, now Big 4 public accounting firm. Oh, they might have, an axe to grind, and they know where the bodies are buried. So, and they went after, there was one big accounting firm. They said, okay, we want to see the names of all of the auditors who audited this, and you would know the name of the bank, this one big national bank. And, lots and lots, dozens and dozens and dozens of young auditors had worked on that. Okay, now we're going to see if any of them had credit cards issued by this bank. And if so, if they had balances over, I forget what the amount is, but if you have a balance over, I think it was at the time like $10,000 that you didn't pay off or bring down below $10,000 by the end of each month, guess what? That's a violation of independence rules. And this firm had to pay a huge fine because they had staff accountants who had too high a balance on credit cards issued by the bank that they did some work on. Wow. The PCAOB investigators can get real nasty. Well, if that's not enough, some years later, Senator, what was his name? Dodd. Tom? Not Tom. Well, Senator Dodd and Congressman Barney Frank came together, issued the Dodd-Frank Act for consumer protection. It regulates Wall Street and reduces big bonuses that the Wall Street people got. And this was after the 2008 Great Recession, and said, okay, the government stepped in and said some of these big, banks, investment banks, they're just too big to fail, and they had to pay them out. And said, no. This legislation, we're never going to have a too big to fail, and bail out these companies. They're going to fail and they're going to go away. They wanted to identify and prevent future financial crises, called for transparency and accountability for complex financial instruments, because the Wall Street guys are coming up with new stuff all the time, and also some investor protections. Then we've got COSO, okay, which is one of the worst acronyms, right? Committee of Sponsoring Organizations, okay, which really you can almost tell that this came up, by accountants. What do we call ourselves? How about the Committee of Sponsoring Organizations? Oh, okay. And we'll shorten it to COSO. But they had the Enterprise Risk Management Framework, or ERM, okay, that said, all right, let's identify the principles and components of effective risk management. Okay, what's the process involved here, and how risks should be identified, assessed, and addressed. Create an anti-fraud environment and help entities achieve their operational and financial objectives and goals. That was their marching orders. Okay, so just know that it's out there, and you'll hear people talking about COSO ERM. Okay, they're not speaking a foreign language. They're speaking accounting, which is kind of a foreign language. Then you got the IIA, the Institute of Internal Auditors. Okay, private, nonprofit foundation. I think it's a foundation, but it's a nonprofit organization that also credentials internal auditors as certified internal auditors with the unfortunate acronym of CIA. And they issued advisories 1210A1 and 1210A2 that says that internal audit can be an integral resource in creating an anti-fraud environment. And that's so true. Okay. If nothing else, the outside auditors come in, a couple of weeks, a couple of months a year. The internal auditors are there all the time. So the Institute issued these two practice advisories that addresses identifying fraud and the internal auditor's responsibility for fraud detection, respectively. They've got great rules with regards to their, even though they're employees of the company, they should be treated independently, and they have to be non-report to the audit, not to the president. I was brought in where the internal auditor reported directly to the president, who was a bit corrupt, and he would use internal auditors to punish his enemies within the organization. That's not the role of internal audit. Okay, examples of frauds designed to benefit the organization. Okay, these are kind of frauds not to benefit a particular individual. Oh boy. Is everybody? All right. Is everyone still there? Okay. Yeah, I had can you hear me now? Raise your hand if you can hear me. Okay. Yeah, I had a bit of a problem there with my audio or something. So I might have a little problem with the. Okay. All right. So we'll continue on with this, and we only got a few slides left, so let's finish this off, shall we? And get out of here. All right. All right. So this is slide 83 of 89. So let's finish up. Okay, these are frauds committed not to benefit okay, let's see. Michaela, you have your hand up? Okay, took it down. All right. Not to benefit an individual, but to benefit the organization, such as booking sales or the assignment of fictitious or misrepresented assets. Okay, so the sale or assignment of fictitious or misrepresented assets. The improper payments, such as bribes, intentional improper representation or valuation of transactions, assets, liabilities, or income, intentional improper transfer pricing, intentional improper related party transactions, intentional failure to record or disclose significant information to outside parties, prohibited business activities such as those that violate the law, and of course, tax fraud. So these are designed to make the company look good, right? Make the company benefit, not necessarily any individual, at least not directly. So what about ones that are detrimental to the organization? Well, you're the head of purchasing and you're accepting kickbacks. Yeah, that's detrimental, especially when you're allowing the company to buy overpriced goods so you can get your kickback. Diversion to an employee or outsider of potentially profitable transaction. Embezzlement, always detrimental to the organization, including efforts to falsify the records to cover it up. Intentional concealment or misrepresentation of events or data, and claims submitted for services or goods that you didn't actually provide. Yeah, that all qualifies. So internal auditors should be looking for all that stuff. and they should consider whether the organization environment fosters control consciousness, whether the organizational goals are realistic. Okay, are their objectives realistic? Do they have written policies? Okay, in response to policy violations? They have authorization for transactions, both existence and implementation. Are policies, practice, procedures, reports, and other mechanisms developed to monitor activities and safeguard assets? Have they open communication channels that provide management with adequate and reliable information? And is the response to recommendations to establish or enhance cost-effective anti-fraud controls? I mean, are they doing it? Okay. So, if an internal auditor is conducting a fraud investigation, they should, one, assess the probable level and extent of complicity in the fraud within the organization. Okay. Especially if it's the big bosses involved, right? Determine the knowledge, skills, and other competencies needed to carry out the investigation. And if you don't have them, okay, either acquire, the knowledge, the skills yourself, take some courses or whatever, or, oh, I see my camera's still on. Hi. Or hire someone. Design procedures to identify the perpetrators, the extent of the fraud, the techniques used to perpetrate the fraud, and the underlying causes. Coordinate activities with management personnel. That second one's, in my opinion, the very important one, legal counsel and other specialists as appropriate. Be cognizant, and if you're publicly traded companies, talk to the outside independent auditors, get them, up to speed with this as well. But be cognizant of the rights of the alleged perpetrators and personnel, the reputation of the organization itself, which is why you want to get legal counsel in on this. You don't want to get charged with violating someone's rights. Corporate governance, what's its role? Protect the investor, create long-term shareholder value, restore investor confidence. In a sense, that's why I'm going to Washington next week. Talk about restoring voter confidence by implementing some controls, use of independent auditors, etc. Support strong and efficient capital markets. The committee must ensure its independence. And again, you want to establish and pronounce a positive tone at the top. Mechanisms include, again, have a good organizational code of conduct that isn't just something that the PR firm came up with. It's real. It's supported by an embedded culture of honesty and ethical behavior. You can go online. For the past 50 years, the Gallup organization has taken a survey. They have Americans rate different occupations. I think I've mentioned this before, as to their ethics and honesty as being very high, neutral, low, and very low. And then what Gallup does, and they say, okay, well, combine those first two columns, high and very high, ethics and honesty. Okay, add them up. Who had the highest score? And last several years, nurses, always number one. They're regarded to have high ethics and honesty. What I do with that data is I flip it over and I said, okay, let's add up the columns low and very low. Okay, so who are the Americans perceive as having the least, the lowest honesty and ethics? Number one, members of Congress. But business executives are way up there. Okay, government officials, way up there. Journalists, way up there. At the bottom, the folks that Americans feel, let's put it this way, they can distrust, or who they distrust the least. Again, nurses, but also accountants. Okay, so just put it out there. People think highly of accountants, or at least what they mostly think about is neutral. But when they do think about us, they weren't pretty good. At least they don't think we're bad. Okay. So how'd I get on that? I don't know. That's that culture of honesty and ethics. Okay. People think accountants, and I believe that's true to a great extent, believe in honesty and ethics. You want to have an independent and empowered board of directors and an independent and empowered audit committee. Organizational policies and reward systems that are consistent with your ethics, confidential disclosure methods, and effective legal risk assessment. Oh my goodness, that's the last slide. Ooh,